All right, hey everyone, this is Angie Holloway, Managing Partner of Edmonds Law Office, a small business firm here in Atlanta, Georgia. And in this short video, I'll show you 4 reasons why LegalZoom contracts hurt your business. All right, so I am a woman of my word, so let me go ahead and get this timer started for you guys. All right, and let's get into it. All right, so what are we going to be talking about in this video? We're going to be talking about the fact that when you buy a digital product from LegalZoom, you are not getting legal advice. It is a digital product. And so there is no attorney-client relationship. Oftentimes there is bad law, meaning the law that is within that contract does not apply to your specific jurisdiction. Thirdly, there is missing specificity in that contract. So what that means is a whole bunch of gray areas and loopholes that can end you up in court. And last but certainly not least, there is thousands of dollars of risk, particularly for scaling businesses that provide high-level services. All right, so who am I? My name is Angelique Holloway. Most of my clients just call me Angie. I am a business lawyer. I've been practicing law for almost 8 years. For the first 6 or so years of my practice, I was dedicated to doing civil rights work, discrimination work in the housing, employment, and contract sectors. About almost 2 years ago, I transitioned to focus my practice exclusively on helping my clients avoid court. And so I serve as outside general counsel to small service-based businesses here in Georgia. But more on that later. All right, let's just get right into it, y'all. Let's look at the actual legal terms and conditions. You can go directly onto the site and click on the terms and conditions and see the exact same text that I'm getting ready to show you today. All right, so this is a screen video of the actual terms and conditions on their website. So they're basically explaining to you that if you choose to use these services, these contract templates, these digital products, you do it at your own risk because we are not lawyers. We cannot provide you with legal advice. And the information that is contained in this contract may or may not be correct. And so this huge disclaimer is basically warning you that if you choose to go forward with this course of conduct, it is at your own risk. All right, y'all, let's think about who knows what happens when you buy a $99 contract from LegalZoom and you end up in a legal dispute that costs you tens or hundreds of thousands of dollars. You might as well just throw that contract in the trash, y'all, because you get what you pay for. If you choose to purchase a digital product from LegalZoom, your only recourse is going to be to get the same $99 back that you paid, right? So in situations where you are having a high value service or the cost of the partnership, the vendor relationship is going to be significant, more than that $99, then it is in your best interest for you to consider hiring competent legal counsel. Here you'll see all of the liability waivers that you would be agreeing to if you purchase that $99 contract. In short, what this is saying is we aren't liable for any damages. We can't guarantee that the actual contract is going to be fit for any particular purpose. And in the event it causes you damages, the most you can sue us for, actually you can't sue us because you agree to mandatory arbitration. So the most you can recover in a mandatory arbitration is going to be $99. All right, so highlight reel. What is the primary purpose of this video? Bad contracts cost you money. First of all, the terms and conditions tell you, buyer beware. Hey, if you use this, it's at your own risk. We are not a lawyer. We're not a law firm. We encourage you to seek counsel from a licensed attorney. Number 2, it is bad law. A lot of times these contract templates are one size fits all, which means that the same contract that somebody downloaded in Texas is the same one they're giving to you in Georgia. So this law may not even be enforceable in the state that you're in. And I've seen this on countless times in agreements where indemnification in Georgia that may be permissible in other jurisdictions. Number 3, it's the wrong law. the completely wrong law. And so what that means is that you may or may not be having portions of a contract that are unenforceable. It creates a bad experience for your clients, as well as a bad reputation for you in the event you do have to enforce those provisions, and then you come up against an attorney that says, hey, this is unenforceable in the state. And number 4, like we just went over, there is no recourse. If you paid $99 for the contract, the most you can recoup is $99. I have seen this on so many occasions where someone used a $99 contract and it cost them $100,000, $200,000 because they didn't have the proper counsel alongside that contract. All right, y'all, so let's get into it. How do we fix crappy contracts? At Edmonds Law, we craft custom contracts that you can use when you are scaling your business. All right, so unlike what most people think, writing contracts is not a copy and paste process. This is the system that we use for each of our clients that comes through and works with us, either for an a la carte or if they're working with us as outside general counsel clients. So the first step in the process is to research. We're getting to know your business industry. We're getting to know your business. So the way that you onboard new clients, the way that you book calls, what are your terms and conditions? What is your process and procedure? Are you working with vendors? Do you have staff, right? And so the first step is for us to get to know your industry specifics and how you are running your business to identify what those biggest risks are. We're going to look at your contracts. We're going to look at your insurance coverages, and we're going to evaluate your team and how you're operating to see if there are loopholes, if there's opportunities where clients are not having the same client experience, for example, or clients that are being onboarded without signing electronically their specific proposals. Any part of your customer journey where there's opportunity for risk, we're going to evaluate that and create a prioritization of that risk. The third step is implementing our risk assessment plan. So we are going to identify, hey, if you have employees and you don't have adequate non-compete provisions for key sales professionals, for example, that may be the highest priority for us to be able to correct in your business, right? So we're going to fix that immediately, have all your employees sign your new employment agreements, right? And then we are going to look at your insurance. It's not just a matter of having insurance, but it's a matter of making sure you have adequate coverage, as well as that you are complying with conditions precedents to make sure that you're not in a position where an insurance policy is going to deny a claim when you need it. And then lastly, we do some human resources management, making sure that you're avoiding any type of claims that may arise with respect to employee management, wrongful termination, and those types of things. Once we have implemented your plan, this may be a 3-month, 6-month, or 12-month plan, then we're going to check in periodically every 6 to 12 months to see, okay, are you offering new services? Do we need to make some adjustment to your contracts? Do we need to make sure employees are getting retrained on the onboarding process to make sure there's an alignment of the risk management strategy? All right, y'all, so let's get into some show and tell. So I'm going to tell you 2 recent clients that I've worked with related to some crappy contracts, okay? So the first one is a client that I worked with. It was a couple. They had enrolled their child at a private school. A number of things happened such that they wanted to get out of that contract, right? They had a mandatory provision in that contract, which meant that they could not get a refund even if they decided to disenroll their child, right? So I evaluated the contract, went over the case law. They had a number of things in that contract which were void, right? And so because of that, and they're missing a severability clause, we had leverage to negotiate and get out of that contract, and I saved my client $100,000. Another incident I want to tell you guys about, there was a daycare business owner, and she went into business with one of her best friends from high school. I always encourage people not to do mixed business. Putting that aside, they decided to get a template for their LLC operating agreement from LegalZoom. Unfortunately, there was no specific way for them to get out of the business, right? And so normally what you'll have is a buy-sell provision, or you'll have certain conditions under which the business is automatically going to go into dissolution. those two provisions, those key provisions on how you get out of the business were completely missing from their operating agreement. And so what that meant was that my client had no legal means to actually get out of the contract, to get out of this business when she was miserable working with her former high school best friend, and ultimately ended up having to file bankruptcy for the business. So this is real world stuff. I know it seems like, you can get a contract from ChatGPT or LegalZoom without repercussions, but as you scale and grow as a business owner, you have to invest in real legal insights and expertise. All right, y'all, so here's some of the fines, right? So the real cost of using LegalZoom. The average cost to defend a wrongful termination lawsuit, this was from 2 years ago, so this cost may have increased, is $160,000 from the filing of a wrongful termination suit all the way to motion for summary judgment, okay? I don't know about you guys, but I don't have $160,000 to spare in my business to defend against a wrongful termination lawsuit. That is what it costs. It doesn't matter whether or not that wrongful termination lawsuit has merit. This is the cost for you as a business owner to defend it, right? Number two, $7,500. This is the cost that you would pay as a business owner for misclassifying a worker as an independent contractor when they should be an employee. So in 2022, the laws changed and people that were formerly classified as a 1099 worker are now mostly employees. So if you have a staff of 100 or more, it's $7,500 per employee that you misclassify. If it's less than that, it's $2,500 per employee. All right, this last statistic, this is the amount of money that clients that I have consulted with this year have lost due to poorly drafted contracts. $635,000. This is not nickel and dimes, you guys. This is a huge amount of money that clients I've consulted with. Some clients I was not able to assist, right? They signed a poor contract. It resulted in some huge loss or opportunity in their business, and that was the end. All right, guys, so we're coming up on the end of the time. I really appreciate you for taking the time to watch this short video, learning 4 things that can really jeopardize the safety of your business as you're scaling and growing. If you're ready to upgrade your contracts, book a call by clicking the link below. Talk soon.